Ooh.
And where does he go from here? This is an existential crisis for Harry. And I thought his reaction afterwards with the angry response to the verdict, which strangely Doreen Lawrence was a co-signatory of, but if you read the text and if you read lines like total whitewash, that doesn't sound like Doreen Lawrence to me. Sounds like Harry. So I think what's happened, guys, is that he sued in anger. You should never sue someone when you're angry. You got to have cool heads, calm, rational arguments, and it's always a risk. Instead, he's gone in like a bull in the china shop.
Just 2 days ago, a dramatic showdown unfolded at the Royal Courts of Justice, putting one crucial promise made by Prince Harry on July 7th under a fierce spotlight. This wasn't just any promise. It was a commitment with serious financial consequences, tested against the cold, hard reality of the legal bill attached to a high-profile, headline-grabbing case. And against all expectations, it stood firm. The Guardian headlined the outcome in stark terms. Doreen Lawrence will not pay any part of the legal bill following the failed attempt to sue the Daily Mail. This wasn't some ordinary news story. Baroness Lawrence, whom Prince Harry had personally persuaded to join this battle in January 2022, emerged entirely unscathed financially. No debts, no bills, nothing. That much is beyond dispute, officially confirmed in court.
Publishers of the Daily Mail argued that the claimant Harry and his team and their legal team handled the case in such an exceptionally improper manner that the court should require them to pay costs on an indemnity basis.
But here's where the story takes a sharp turn, and where most coverage has missed the bigger picture. While Lawrence walked away free from financial strain, the scale of the total legal costs didn't disappear, it intensified, ballooning into something far bigger. The court revealed that the combined insurance on the claim covered a staggering £16.2 million. However, the actual costs already racked up by Harry's legal team have soared past £34.5 million. That means there's a glaring gap, an enormous shortfall of at least £18.3 million. And once again, just to be clear, Baroness Lawrence isn't footing that bill. So, if she's out of the picture financially, who is absorbing this massive deficit? The court unveiled 6 key figures now carrying this immense burden: Elton John, David Furnish, Sadie Frost, Elizabeth Hurley, Simon Hughes, and of course, Prince Harry himself. They're not just names on a roster, they're the ones collectively responsible for settling this mounting bill. What's vital to understand here is that the bill didn't magically disappear just because Lawrence was exempt. Instead, it became laser-focused on this smaller group, concentrating the financial weight squarely on their shoulders. Yet, even with such a glaring headline, one crucial detail slipped through the cracks in most reports. Judge Nicklin, while delivering his remarks in court, didn't actually announce the final figure. Instead,
So the bottom line is that reputationally it's been a disaster. Financially, it's Armageddon. I mean, what is Harry on the hook for? Let's get down to brass tacks. 10, 15, $20 million is what Harry is facing.
he made it clear his decision on the exact amount, whether it would be the standard cost or the harsher indemnity rate, will come later in a written judgment. That means we're still waiting for the full breakdown of how this colossal sum will be divided up. However, what the judge did make crystal clear was the deadline looming over these 6 individuals. By August 28th, an interim payment must be made, a substantial single payment to be confirmed in the forthcoming judgment. Judge Nicklin said it plainly. They are going to be paying a sum of money that I will confirm in the judgment. This will be one global figure, one lump sum, which will then be allocated among these 7 people. By the time you hit minute 18 of this story, you'll grasp the significance of the 3 words the barrister representing this case used to describe the entire situation. You'll discover fascinating insights about the legal team's own budget, a detail that cuts both ways, with implications that might surprise you. With just 4 weeks left until the payment deadline and no definite amount revealed yet, Prince Harry stands as the most exposed name among the group. The promise held true. The deadline is set, and the stakes have never been higher. Here's where the story takes a sharp turn, transforming what seemed like a straightforward numbers game into a high-stakes financial battle. At first glance, It might seem puzzling. Why would confirming protection for just one individual suddenly shift the financial exposure for 6 others?
He's incapable of restraining his emotions and his outbursts. He's still behaving as if he's 16 behind the bike sheds, and she said this to me, she said that to me. Can you believe it?
The answer lies deep in the ruthless world of legal costs. This isn't about fairness or sympathy. It's about cold, hard numbers and who's left standing on the financial battlefield. The principle governing costs doesn't bend to emotion. It's a stark calculation based on which parties remain liable after others are protected or dismissed. The drama unfolded over 2 intense days, beginning promptly at 10:30 a.m. on July 12th, in a courtroom that had already seen monumental decisions. Fast forward to July 29th, when Judge Nicklin, the very same judge who, in an exhaustive 436-page ruling on July 7th, dismissed all 97 allegations, now had to wrestle with a new, equally complex question. Who foots the bill, and how much? On one side stood Anthony White, KC, representing Annal, the defending party. With calm precision, he argued in favor of the indemnity basis for costs. This approach flips the usual burden. Under indemnity costs, Annal wouldn't have to prove that its legal expenses were proportionate to the claims against it. It only needed to show those costs were reasonably incurred. This subtle shift substantially raises the stakes for the judge, who must then decide whether the expenses were justified without the usual measure of proportionality. Meanwhile, Nicholas Bacon Casey, speaking for the claimants, pushed back strongly. He advocated for the standard basis, a less punitive approach that requires a more balanced scrutiny of costs, ensuring they are fair and reasonably connected to the matters at hand. Judge Nicklin, however, chose not to deliver an immediate ruling in court. Instead,
it's been a reputational disaster because he sues the one newspaper that never hacked, which was the Daily Mail. He incurs the wrath of the legendary Paul Dacre, who was the editor at the time of these allegations. Harry has annoyed Mr. Justice Franklin, the heroic judge, at certain points in the trial, saying it's not your job to litigate, that's why you've got lawyers.
The decision was slated to be released in writing later, adding a layer of suspense to this already tense phase. Then, the cold, hard figures came into focus, numbers that laid bare the financial chasm between the two sides. Combined insurance coverage from the claimants totaled a hefty £16.2 million, while Annal's declared costs skyrocketed to £34.5 million. This left a yawning gap of at least £18.3 million, a vast sum demanding explanation and resolution. Annal's demand for an interim payment echoed loudly through the courtroom, nearly £9.95 million, a staggering figure that underscored the monumental pressure building behind the scenes. In response, the claimants offered just over £7.9 million, setting up a clear clash over what was reasonable to pay as litigation continued. Nicholas Bacon Casey didn't mince words, branding Annal's demand on the record as manifestly excessive, a phrase heavy with criticism that illustrated just how far apart the two sides were in their financial expectations. Then came a pivotal confirmation. The Guardian's statement arrived. Lawrence was out, protected. The promise Harry had made on July 7th was holding up. But this protection, while a win for Lawrence, didn't erase the financial divide. Instead, it sharpened the focus, shrinking the pool of names liable from 7 to 6, but leaving the staggering £18.3 million gap intact, now more concentrated among fewer individuals. Harry, in particular, found himself bearing the brunt of this pressure.
Ooh. And where does he go from here? This is an existential crisis for Harry. And I thought his reaction afterwards with the angry response to the verdict, which strangely Doreen Lawrence was a co-signatory of, but if you read the text, and if you read lines like total whitewash, that doesn't sound like Doreen Lawrence to me. It sounds like Harry.
His financial situation, by far the most publicly scrutinized and strained, painted a troubling picture. The betrayal by Bowers on March 26 still hung over him, a shadow spiraling into a staggering £3 million annual burn rate. Revenue streams, a vital lifeline, were drying up across key platforms like Netflix and Spotify. Adding to the strain, any equity Harry held in Netflix vanished back in early March, stripping away a crucial financial cushion. Elton, one of the co-claimants known for having the deepest pockets, reportedly made a choice that added another twist to the drama. When directly approached about stepping in to cover the Invictus shortfall, he declined. Not only did he withhold support, but he also chose to distance himself from Harry's post-verdict public statement, leaving Harry facing the financial storm largely alone. In this swirling mix of legal maneuvering, financial pressure, and strategic alliances or lack thereof, the tension keeps building, setting the stage for what could be a pivotal turning point in the saga. The courtroom drama grows ever more complex, where every decision, every refusal, every protection confirmed reshapes the fate of those entangled in this costly conflict. Here's where things get truly intense. The promise made still stands firm, no reduction in the bill, and the judge's final ruling is still pending. The crucial date looming now is August 28th, just 4 weeks away, but with no clear number attached to what's owed. This detail is something that most reports have somehow missed or misunderstood. On July 30th, Judge Nicklin didn't simply stand up and declare the exact sum Harry must pay. Instead, he reserved his judgment.
The fact that of all the famous people that came to Canada, all the presidents, all the prime ministers, the single biggest expense was Prince Harry. I mean, that does stick in the craw.
Which is the formal way judges take their time to carefully craft a detailed decision, rather than giving an immediate verdict right from the courtroom bench. What Judge Nicklin did confirm, however, was that Harry will definitely be required to pay money. He promised this would be officially confirmed in the written judgment. The key point is the deadline for this interim payment, August 28th. So here's the unique and rather puzzling situation we have now. There's a hard deadline that must be met, but there is no firm number on the amount due. Not only that, the court has not yet clarified whether the costs must be calculated on a standard or indemnity basis. This is actually a huge deal. Bacon KC, one of the top legal experts involved, described this choice as potentially the most financially impactful part of the entire lawsuit. On top of this, the court was told that the payment figure due will be a single lump sum covering all 7 claimants. The question of how this large total will then be divided among those claimants hasn't been decided yet. It's a separate matter altogether. So, right now, Harry is faced with an impossible challenge. He has to pay a significant bill in just a month's time, but he has no way of calculating how much that bill might be, or on what basis it will be assessed. You might be thinking the total must be something between 7.9 million and 9.9 million, and if that's split evenly between 7 people, it sounds manageable on a per-person basis. But group litigation doesn't work like that. The cost orders aren't split silently into equal pieces. Instead, the division depends on how involved each claimant was, their behavior during the case, and even their ability to pay. Adding to the complexity, one of the 7 claimants has already been ruled exempt from paying, which means her share will get redistributed to the remaining 6. This all happens before the final division has even begun. And that brings us to some powerful and intriguing words from Annal's barrister, whose remarks might just shed light on what could come next in this tangled, financially charged saga. When examining the finer details of this case, 3 particular points stand out. These are the markers that separate a lawsuit that simply ends in defeat from one where the court is actually pushed to impose financial penalties. It's more than just a loss. It's about crossing a line where the legal system signals that something deeper is at play. Revelation number 2 unfolds like a dramatic legal thriller, what one barrister vividly described as a banquet of litigation. Anthony White KC, who was arguing in favor of indemnity costs on July 29th, painted a sharp and colorful picture of the situation. As reported by Yahoo News UK, White KC accused the claimants of casting a strikingly wide net, hoping, in his words, to catch some fish. Think about that metaphor, a wide net tossed into turbulent waters, not just to catch a specific proven wrongdoing, but to drag up anything at all that might support their case. Then came the phrase that changes everything the moment the narrative shifts dramatically. White KC called these proceedings the vanguard, or first wave of what he labeled, quite deliberately, a banquet of litigation. Pause and feel the weight of that phrase. This isn't neutral courtroom speak. This is a pointed, almost theatrical accusation from the opposing counsel right there in open court. It suggests this wasn't about a focused, earnest complaint. It was the opening salvo in what could be a relentless series of legal battles. White KC pushed even harder. He described the allegations as both extraordinarily broad and incredibly serious, untethered from concrete evidence, and instead driven by a strategic playbook. He implored the court to step back and consider why the claimants cast their net so wide, implying that the answer wasn't about the strength of proof, but a calculated tactic designed to overwhelm and intimidate. But the drama didn't stop there. White KC drew the court's attention to a particularly controversial moment, the post-verdict statement made by Harry himself. This statement, uncovered and reported just recently, was portrayed not as a mere response, but as a deliberate, far-reaching attempt to stir up global attention and effectively keep the claim alive in the public eye. According to White KC, this was more than commentary. It was a sustained allegation of wrongdoing against the publisher, even after the court had dismissed every single claim. So, what exactly was White KC's full argument on indemnity? Simply put, it wasn't just about the fact that the claimants lost the case. That, in itself, wouldn't be enough to trigger harsher financial consequences. Rather, it was the combination of how broadly the claims were made and the conduct following the court's decision that, in his view, justified a tougher penalty. On the other side, Bacon KC stood firm in opposition, contesting this interpretation fiercely. Ultimately, Judge Nicklin will deliver a written ruling on whether to grant indemnity costs, but the intensity of the arguments has already left a strong impression etched firmly into the official court record. It's clear this case is far from over in terms of its legal and financial fallout. Now, let's zero in on the judge who holds the fate of this entire case in their hands. But before that, there's something crucial you need to hear what Annal's own barrister had to say about Baroness Lawrence. This moment is absolutely key because it reveals why the exposure landing on the other 6 claimants matters so much more than on Lawrence herself. Annal's lawyer, White KC, didn't mince words. He openly admitted he felt a pang of sadness that Baroness Lawrence was, in his terms, recruited to be a national symbol or, as he put it, a national treasure. It was a strategic move for the case, and while it's a subject of regret for Annal personally, it's also something they refuse to shy away from. Now, hear that carefully, this isn't just about sympathy, it's a calculated acknowledgement. The word recruited is a loaded admission. It tells you that Baroness Lawrence's high profile was deliberately leveraged, her status used as a powerful tool beyond just her individual experience. This admission does 2 critical things at once. First, it protects Annal from appearing to be attacking a beloved, respected public figure. Nobody wants to be seen as targeting someone with Baroness Lawrence's legacy. Second, it reinforces the whole framework of the litigation as a carefully orchestrated strategy, one in which high-profile names were deliberately brought in to add weight and public sympathy to the legal battle. The media picked up on this too. The Guardian ran a headline that couldn't be clearer: Doreen Lawrence will not foot any of the legal bill. That protection is rock solid and officially confirmed. But here's what the headlines don't get into deeply enough: the how and why of that protection actually works. Her legal shield isn't magic. It relies heavily on a public pledge made by Prince Harry on July 7th, where he explicitly promised to cover her costs personally. That leads us to a big question that has gone largely unanswered. If Harry's pledge is the source of her protection, and if he's not known for having vast amounts of disposable wealth just waiting, then exactly where does her share of the legal bill end up? It's not disappearing into thin air. When you remove Lawrence from the equation, that still leaves a minimum gap of £18.3 million and 6 other claimants who are still on the hook. Think you've heard all there is about overspending on this case? Hold tight. The bombshells aren't over. In fact, what the claimant's own barrister has now let slip about Annal's actual legal budget will likely blow your mind. The story is just unfolding. Stay with me. Here's where things get really intense, and the numbers tell a story you won't believe. The side that won this case didn't just breeze past its own court-approved spending cap, they blew right through it by an amount that exceeds what most entire trials cost from start to finish. And all of that happened within a mere 3 minutes, if you can imagine. But before we dive deeper into the financial fallout, let's zoom out and address where the focus truly lies now that one major name has been taken off the table. This brings us to Revelation 4, the 6 remaining names still in the mix. Back in October 2022, 7 claimants were officially filed. Since then, 1 has been confirmed as exempt, which leaves us with 6 key players to keep our eyes on. So who are these 6? What's going on with each of them? Let's break it down, piece by piece, so you can see the puzzle come to life. First up, Baroness Lawrence. As of July 29th, she's officially been declared exempt from financial responsibility. That means she's out of the money game here. Moving on, Simon Hughes, the former Liberal Democrat MP, has gone on record to express his reaction to the verdict, and it's not a happy one, calling it very disappointing for me. And I'm sure for all other claimants, Hughes provides us an emotional insight, but offers no public hint about his capacity to contribute financially at this point. Then there's Elizabeth Hurley, a figure who's been notably quiet since the verdict went public. Same goes for Sadie Frost, another name on the list keeping their silence, leaving us wondering about their next moves or financial positioning. Now, the fascinating financial heavyweight, David Furnish, who is widely known as Sir Elton John's husband. He brings with him the most substantial documented financial backing in this entire group. Yet, in a twist that surprised many observers, reports indicate that he refused to cover the shortfall related to Invictus when Prince Harry came knocking in early July. Notably, his name was absent from Harry's post-verdict response, leading to a reported pushback, simply put, "I'm not an ATM" stance that has only added fuel to the fire. And then, of course, comes Prince Harry himself, the name dragged under the microscope like no other in this saga. Financially, he's under an unprecedented amount of scrutiny. From allegations about a staggering $3 million annual spending rate to drying income streams across numerous fronts, every penny he has is being heavily analyzed. On July 13th, Paula Froelich summed it up bluntly when she stated, "Harry does not have that kind of money just lying around." So let's do the math. Among these 6 remaining people, 1 is documented to be facing cash flow issues. 1 has publicly made it clear they won't be footing any further bills. 2 remain tight-lipped. 1 is quiet but measured. And 1 is financially linked to another party. Even though this legal bill lands technically on all 6, the real pressure, the immense weight of this financial burden falls almost exclusively on Prince Harry. His name is the one every headline is chasing, the one whose finances are under the harshest spotlight, and the one who is most publicly linked to the fallout. The story here isn't just about money, it's about how one person becomes the lightning rod for an entire group's financial strain, and what that means moving forward. The very reason Lawrence's exemption was secured in the first place now becomes a double-edged sword, trapping the entire narrative in a vortex of budget debates and dollar signs. Locking her protection doesn't just shift the money, it zeroes in every spotlight, every headline onto the same burning question: what exactly does Harry owe? And the answers don't come easy. In fact, they spiral into a tangled web of numbers that cuts both ways, with complications for the winning side that few have dared highlight yet. Here's the jaw-dropping reveal nobody saw coming. Nicholas Bacon KC, representing the claimants, dropped a bombshell buried deep in written submissions. Annal's team had already racked up costs nearing a staggering $34.5 million. Pause for a moment and let that sink in. That's over $18.6 million beyond their own court-approved budget. To put this into perspective, The court had slapped a spending cap on the claimants of $4.1 million back in 2024, making this jaw-dropping overshoot more than 4 times what was allowed. This isn't a small mistake, it's a fundamental rupture in the financial orders set by the court. Digging deeper into the backstory shows just how extraordinary this is. Back in 2024, a detailed judicial examination took place, scrutinizing both sides' proposed budgets, combining for a whopping $38.8 million. The court found this colossal figure manifestly excessive and, importantly, disproportionate. As a result, it imposed strict caps $4.1 million for the claimants and around $4.5 million for Annal's side, aiming to keep things within reasonable bounds. Yet, fast forward to 2026, and Annal's actual expenditures explode to $34.5 million, shattering the court's carefully drawn limits. Because of this, Bacon KC didn't hold back in his critique, describing Annal's interim $9.9 million demand as manifestly excessive, deliberately echoing the court's own formal language from 2024. It's almost poetic justice, a warning shot fired back at the side now aggressively pushing for payment, undermining their credibility in the process. However, this twist doesn't provide a clean win for the claimants either. Even if the court decides to significantly cut down on what Annal can recover due to this overspending, the hard boundary set by the $16.2 million insurance cap remains firmly in place. In his written warnings, Bacon cautioned, "If the court orders payment on," a statement hanging in suspense, hinting at the complex and unresolved financial dynamics still unfolding in this dramatic legal saga. The budget battles are far from over, and every dollar spent or recouped reshapes the stakes in this ongoing courtroom drama. Let's dive deeper into the complex web of numbers and legal battles that have defined this case. Imagine standing at the crossroads of millions, where every figure tells a story of high stakes and tense negotiations. The crux of the matter lies in the basis on which costs would be covered: standard or indemnity. If the indemnity basis applied, the insurance coverage would fall drastically short, leaving a gaping hole, potentially running into many millions of pounds. This isn't just speculation. The claimant's own barrister explicitly confirmed this shortfall in a written statement to the judge. So, the tension is real. This isn't merely Annal's view. It's the losing side's own legal representative acknowledging a substantial financial gap. Right now, the full picture is anything but clear. The court has reserved judgment on the exact basis for cost calculation, leaving everyone on edge. We know that an interim figure has been proposed, hanging somewhere between £7.9 million and just under £10 million, but it's yet to be confirmed officially in writing, with a looming deadline of August 28th. Meanwhile, the insurance ceiling stands firm at £16.2 million, but Annal's claimed costs tower at a staggering £34.5 million. This leaves a minimum gap, a chasm, really of around £18.3 million that remains unaccounted for. To add to the complexity, the Lawrence team remains exempt from these particular numbers, while the claimant's own barrister reiterates that this shortfall could spiral into the tens of millions, heightening the financial drama exponentially. Now, let's add some key timestamps to bring this saga to life. It all started in January 2022, when Harry personally reached out and emailed Baroness Lawrence, sparking her decision to join the case, a turning point initiated by his direct appeal. Fast forward to the 6th of October 2022, the lawsuit officially filed against Annal, with 7 claimants taking legal action. 2 years later, in 2024, the stakes escalated with pre-trial cost management hearings, where a combined spending proposal nearly topped $38.8 million. However, Judge Cook slammed down the hammer, calling these sums manifestly excessive and disproportionate. The claimants were abruptly capped at just over $4.1 million, while Annal was limited to roughly $4.5 million in costs, slicing the projected spending dramatically. The courtroom drama peaked in January 2026, when the 11-week trial kicked off, a marathon session destined to test every ounce of legal endurance. Then came the 7th of July 2026, a watershed moment when the verdict was delivered, dismissing all 97 allegations in a sprawling 436-page ruling. Amid this upheaval, Perry publicly vowed to protect Baroness Lawrence from any financial liability, offering a rare moment of solidarity amid the chaos. The story continued on the 29th of July 2026, day one of a new phase, when Annal demanded an interim payment of nearly $9.95 million. The claimants pushed back, countering just above $7.9 million. The court then heard that insurance coverage was capped at $16.2 million, starkly contrasting with Annal's towering costs of $34.5 million. Bacon KC didn't hold back, revealing that Annal had already blown past its own approved budget by over $18.6 million, labeling Annal's demands as manifestly excessive. Meanwhile, White KC fired back in favor of indemnity, framing the case as emblematic of enormous financial risk and sparking intense debate over the true scale of the payout. At every twist and turn, the numbers tell a gripping story of legal strategy, financial brinkmanship, and the relentless pursuit of justice where every pound and penny weighs heavily on the outcome that still hangs in the balance. Imagine a courtroom drama that stretches far beyond the headlines, a complex saga where promises, money, and reputation collide in a high-stakes legal battle that's about to reach a critical turning point. The Guardian has just confirmed the inevitable. Lawrence will not be footing the bill. It's the 30th of July 2026, day 2 of the much-anticipated hearing comes to an end. After hours of testimony and legal wrangling, the judge, Nicklin, wraps up the session with a decisive ruling. The interim payment must be made by August 28, but this isn't just any payment, it's a global sum that needs to be split among 7 individuals involved in the case. The appeal discussions are put on hold, postponed until the exact figure of that payment is finalized. Fast forward 4 weeks later, the 28th of August, 2026, the deadline for that interim payment looms large, with only days remaining. What's unfolding isn't just a financial transaction, it's a tangled web of legal consequences, breaking down neatly into 3 key categories that reveal the true depth of the situation. First, we have the promise, that crucial pledge made by Harry on July 7. This wasn't just empty words, it was a solemn vow to personally protect Baroness Doreen Lawrence. The Guardian's reporting backs this up, and even O'Neill, one of the main players in the courtroom, acknowledged it himself in court. Harry's commitment brought a very real outcome, and that certainty is rare and significant in a case this convoluted. But here's the catch. This pledge was confirmed for only one individual, Baroness Lawrence herself. It's a narrow shield, but a powerful one. Next, the financial reality sets in. Stark and unyielding, the bill refuses to shrink. In fact, it's staggering. O'Neill's costs alone reach a towering £16.2 million, while the combined legal expenses soar to an eye-watering £34.5 million. That's a gap of no less than £18.3 million staring down everyone involved. Even the claimant's own barrister has sounded the alarm, warning that if indemnity costs the legal fees awarded to the winning side are applied, this shortfall could swell by many more millions. Here's the twist. Confirming Lawrence's protection doesn't close this financial gap. Instead, it redistributes the burden among the 6 remaining names tied to the case. The payment due on August 28 isn't the final tally, it's merely an advance, a partial settlement, while the full assessment of costs continues to unfold like an unfolding drama. Finally, the third and perhaps most intense category, the concentration effect. The financial shortfall now rests heavily on 6 people, 6 whose names will carry this enormous weight. Within this group, there are 2 who have chosen silence, making no public comment, one who has remained completely quiet, another who shared only a measured expression of disappointment. One person has reportedly declined extra funding and even removed their name from Harry's post-verdict statement. This leaves Harry, the very person who made the pledge, and now finds himself under the most intense scrutiny not just for his finances, but also for a statement he authored, which legal teams are now pointing to in court as evidence supporting the demand for indemnity costs. The burden is distributed to 6, but the heat falls squarely on 1. To sum it all up, on a day branded in history, the 7th of July 2026, Harry publicly vowed to shield Baroness Lawrence from financial fallout. This promise is as real as it is rare in the legal world. But with a bill that refuses to be tamed, with millions at stake, and with 6 individuals now facing the fallout, the question remains, will the pledge hold strong, or will the weight of this costly legal battle prove too heavy to bear? The next weeks will tell the story. In January 2022, Harry took a decisive step. He promised to shield Lawrence, known affectionately and rightly as a national treasure, from any financial burden tied to this complex legal battle. Fast forward to July 29th, and that commitment was officially reinforced in court. The Guardian, Lawrence, would face none of the legal fees. This declaration brought some relief, but it also revealed a much bigger, more tangled web of costs lurking beneath the surface. During the hearing, Ulm's own barrister acknowledged Lawrence's indispensable role, referring to her as a symbol of national significance, a point that underscored the profound weight her involvement carried throughout this case. Yet, that same hearing shed light on just how enormous the financial stakes truly were. The insurance costs alone had ballooned to a staggering $16.2 million. Then there were the overall legal fees, an eye-watering $34.5 million. Even with Lawrence's costs covered, there remained a minimum funding shortfall of $18.3 million that needed attention immediately. An interim demand from Annals topped nearly $10 million, $9,950,524.37 to be exact. Meanwhile, the claimant counteroffered just over $7.9 million. As tensions mounted, Annals' barrister dramatically described the case as a banquet of litigation, a feast of complex legal tussles that required greater financial rigor and justified the steeper cost calculations. He even referenced Harry's own statements after the verdict, suggesting his conduct had contributed directly to the heightened expense. Behind the scenes, the claimant's barrister dropped a telling revelation. Annals had significantly exceeded its budget by a whopping $18.6 million. This financial overrun set the stage for a daunting message. The remaining parties on the claim could face liabilities running into many millions just to bridge the gap left after Lawrence's protection was factored in. Judge Nicklin, presiding with calm authority, reserved judgment on the matter. No final tally was announced. No official cost division was settled. What the judge did confirm was a firm deadline. Payment was due by August 28th, with the total sum to be a single global figure, which would then be divided among the involved parties. This outcome leaves us in a curious position. Harry's promise to protect Baroness Lawrence held firm. She is no longer facing financial risk. But that pledge didn't make the $18.3 million shortfall vanish into thin air. Instead, it simply redistributed this enormous financial weight among the 6 remaining names connected to the case, with the precise allocation yet to be determined. With August 28th approaching, the pressing question remains: what concrete public information exists about how the remaining co-claimants will handle their shares of this cost? Has any one of them formally stepped forward with a clear statement, a legal filing, or a binding commitment accepting responsibility for part of this gap? What we need isn't speculation or hearsay, it's firm evidence, a confirmed declaration, documentation that shows exactly how this financial puzzle is being resolved by those still exposed. So here's the challenge for you watching. Dig deep, look for proof, share what you find, not what you guess. Because this story isn't just about legal fees, it's about accountability, promises made and kept, and how the financial consequences of a landmark case ripple out in ways we're still trying to fully understand. If this story captured your attention, don't forget to hit that like button, subscribe for more updates, and share this video with others who want to follow these evolving developments. Also, Leave your thoughts in the comments below. What do you think should happen next? Your voice matters in this ongoing conversation. Thanks for watching, and I'll see you in the next video.